Pets in Condominium Units, a Landlord's Guide. While many condominium corporations allow pets to varying degrees, more and more condo corps prohibit pets in the building. As a landlord, you must follow the RTA, Condo Rules, and human rights, which often have contradictory information. A condominium corporation's governing documents, which is the declaration, bylaws, and rules, dictate what is allowed in a condo. Some corporations prohibit certain types of pets, and others prohibit pets altogether. This is the right of the condominium. Condos that permit pets will often have specific rules about the conduct of the pet and the pet owner, such as size or weight restrictions, noise restrictions, or rules specific about where the pet may be permitted, such as common areas. The condo rules overrule the RTA with respect to pets. Should the occupant fail to comply with the rules regarding the pet, or should noise, damage, or litter be caused by the pet, the condominium may seek remedies to have the animal removed from the building. The court could ultimately order substantial fines for those that fail to comply, order payment for damages, or ultimately evict the person from the unit. The Condominium Act of 1998 allows a court to determine a tenancy if the tenants have breached a court's compliance order. For litigation regarding pets, animals, and nuisance, the condominium can commence a condominium authority tribunal application. Should the condominium apply to the cat and be successful, the landlord could be responsible for thousands of dollars in costs. But what if the animal is a service animal? A service animal is not considered a pet. They are specially trained animals that perform a service for their owner. An emotional support animal is one that supports a person's psychological condition. The landlord would need to notify the condominium of the presence of the service animal and the need for accommodation in accordance with human rights. The condo may require medical evidence supporting the disability and the need for the support animal. Human rights legislation supersedes the condo rules or bylaws. When renting, a landlord should ensure they clearly identify the pet policy for the condominium during the advertising, application, and approval process before signing the lease with the new tenants. Ensure the lease contains an addendum which includes the pet rules and a copy of the condominium rules specific to pets. Also ensure well-documented communication regarding a service animal to ensure the condominium is aware of the exemption. As a landlord, you need to be aware that a service animal is not considered a pet, and trying to ban a service animal may result in a case against you for discrimination. Work with the condominium to ensure all documentation for the service animal is provided in order that an exemption may be obtained. If the exemption is not granted, keep all documentation in case the applicant, the tenant, or the condominium file a complaint against you. The landlord will ultimately be responsible for any problems or costs that are incurred, so it's best to clearly specify the rules and document the communication to the applicant prior to signing the lease, and then again after the tenant commences their tenancy.